It's 2 o'clock. I call to order the meeting of the Code Enforcement Board of the City of Tarpon Springs for November 14, 2013. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the City of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the Circuit Court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. Procedure of this board follows with each case on its agenda is as follows. First, the city presents its witnesses and exhibits, after which the violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the violator is allowed to make a presentation and present any evidence or documents, and the city can question the violator's witnesses. After both rounds of testimony, both on the part of the city and the part of the violator, each party is asked to give a closing statement, first by the city, then by the violator. After those 3 steps are taken, this board then closes the public hearing portion of the case to discuss it and take appropriate action. Before we swear in, please turn off your cell phones, and I'll have everybody rise, and Tom will open us in prayer.
Father in heaven, we seek blessings on the task before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We gather to make decisions for our community. May we use only our best skills and judgment, keeping ourselves impartial and neutral as we consider the merits and pitfalls of each matter that is placed before us, and always act in accordance with what is in the best interests of the residents of Tarpon Springs. This we pray. Amen.
Amen. And please face the flag and recite the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. And all potential witnesses now please stand and be sworn in by the Secretary of the Board.
Raise your right hands, please. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I do.
I'd like to advance right now to old business.
We need to do the roll call.
Oh, yeah, sorry. Yeah, thank you, Michelle.
Chairman Sansoda?
Here.
Vice Chair Vakasi?
Here.
Mr. Kramer?
Here.
Mr. Vesey?
Here.
Ms. Archer?
Here.
Mr. Dematzis?
Here.
Mr. Sobletsky?
Here.
Mr. Plunkett? And Ms. Dabbs?
Thank you. If we could advance to old business, if you'll turn your packets over to the second to last page. Item number 19, request for a reduction in fine. The property owner is going to be present next month for the December 12th meeting, and so there's a request to postpone until that time. And so anybody would like to make a motion, please do so.
I so move we postpone until December 12th meeting.
Okay.
I'll second the motion.
Any discussion?
Is there a fine going to be still levied since we postponed it?
Well, it'll be determined next meeting.
There's
Well-
not a fine running.
Yeah.
It is running?
No, it's not.
Okay,
Okay.
all right, okay. All right, thank you.
Any other discussion? Michelle, if I could have a roll call, please.
Mr. Sobletsky?
Here, yes.
Mr. Dematzis?
No.
Ms. Archer?
Yes.
Mr. Vesey?
Yes.
Mr. Kramer?
Yes.
Ms. Vakasi?
Yes.
Chair Sansoda?
Yes. Okay, thank you. Motion carries. And now if we go to
You can go back to work.
item number 2 on the agenda. Thank you, Cindy.
Good afternoon. My name is Cindy Sanner. I'm the Code Enforcement Inspector for the City of Tarpon Springs. There is no one in the audience today for any of these cases so far. This is case 13-8000754. The property address is 730 North Diston Avenue, and the property owner of record is Federal Home Loan Mortgage Corporation. This is a proactive case. On August 22nd, 2013, I noticed that the lawn was overgrown and not being maintained. This property was in violation of codes 8-40, duty of maintenance of private property, and 8-52, nuisance prohibitions. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was sent a courtesy letter on August 23, 2013, and a notice of violation on September 13th of 2013, and a notice of hearing sent first-class mail and certified return receipt on October 3rd, 2013. A site visit was conducted prior to each notification being sent. The property was posted on October 30th of 2013. I conducted a site visit on November 13th and found that the front yard had been mowed, but not the backyard. This property is in violation of codes 8-40 and 8-52. I'm making a recommendation of a compliance date of December 4th, 2013, with a daily fine thereafter of $25 per day.
All right. Pretty cut and dry. Give everybody a chance to see the pictures. Cut and dry, get it?
Oh, cute.
Nobody want, okay. Sorry. Pretty straightforward. Would somebody like to make a motion?
I'll make it.
Okay.
I move based on the testimony, evidence, facts presented in law, that at the time of the alleged violations, Section 8-40 and 8-52 of the Code of Ordinance of the City of Tarpon Springs were in force. The respondent has until the 4th day of December 2013 to come into compliance with the code section, or a fine of $25 per day shall be imposed for each day thereafter that the respondent remains in violation of the said code section.
Second.
Thank you. Any board discussion? Roll call, please.
Mr. Zablesky?
Yes.
Mr. DeMontis?
Yes.
Ms. Archer?
Yes.
Mr. Bessie?
Yes.
Mr. Kramer?
Yes.
Ms. Vacasie?
Yes.
Chair Sansota.
Yes. Item number 4.
This is case 13-8000782. The property address is 1015 Coldstream Court, and the property owners of record are Michael and Jennifer Ressler. We received a complaint on August 27th that this property was overgrown. The next day, on August 28th, I conducted a site inspection and found that the lawn, the trees, and bushes were all overgrown. And in addition, the fence was damaged. The house was vacant. A lease pendants for foreclosure was filed on July 29th, 2010, and the property owner currently lives out of state. This property was in violation of codes 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, and 36.03, fences, walls, and hedges. The property owners of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, were sent a courtesy letter on August 28th, a notice of violation on September 10th, and a notice of hearing sent first-class mail and certified return receipt on September 26th. A site visit was conducted prior to each notification being sent. Copies of the documents were also sent to J.P. Morgan Chase Bank at 3 addresses and also emailed to J.P. Morgan Chase. The property was posted on October 30th, 2013. A site visit was conducted on November 13th of 2013. The entire lawn had been mowed, but the fence gates were still damaged. This property is still in violation of codes 8-40, 8-52, and 36.03. I recommend a compliance date of December 4th, 2013, and a daily fine thereafter of $25 per day.
Cindy, the violations are all still in effect because the trimming hadn't been...
Well, I think it's going to probably happen again, so that's why I'm considering that they're still in violation.
Somebody want to make a motion on it?
I'll make a motion.
Thank you.
I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations, sections 8-40, 8-52, and 36.03 of the Code of Ordinances of the City of Tarpon Springs were in force. The respondent has until December 4th, 2013 to come into compliance with the code sections, or a fine of $25 per day shall be imposed for each day thereafter that the respondent remains in violation of the said code sections.
Second?
Board discussion? Michelle, may I have a roll call vote,
Mr.
please?
Zablesky?
Yes.
Mr. Demontes?
Yes.
Ms. Archer?
Yes.
Mr. Bessie?
Yes.
Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Chair Sansota?
Yes. All righty. Item number 5, please.
This is case 13-800000843. The property address is 338 East Lemon Street. The property owner of record is Amy Lynn Shores, custodian for Sterling Trust Company. We received a complaint on September 11th that the property was overgrown and there was trash and debris on it. I conducted a site visit on September 13th and found that the property was overgrown. There was an accumulation of trash and debris on the property, and there were also several broken windows and damaged siding. This property was in violation of codes 8-22, accumulation of trash and debris on private property, 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, IPMC 9-1, International Property Maintenance Code adopted, IPMC 301.3, vacant structures and land, IPMC 302.4, weeds, IPMC 304.2, protective treatments, and IPMC 304.13, windows and doors. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was sent a notice of violation on September 13th and a notice of hearing sent first-class mail and certified return receipt on October 4th. A site visit was conducted prior to each notification being sent. The property was posted on October 30th. During a site visit conducted on November 13th, I noticed that the property had been mowed and cleared of the trash and debris. However, the broken windows and damaged siding remain. Although some of the codes have come into compliance, please find this property owner in violation for all originally cited codes of 8-22, 8-40, 8-52, IPMC 9-1, IPMC 301.3, IPMC 302.4, IPMC 304.2, and IPMC 304.13. I recommend a compliance date of December 4th with a daily fine thereafter of $50 per day.
I have a question. How can we find these people in violation if it has been fixed?
I don't understand. What did you say?
Again, like with the other ones, how can we find them in violation of trash and debris if that's been cleaned up?
To be established.
Okay. But we're not, I don't know, it seems kind of like not right that,
And that would be, you'd have to ask Attorney Trask about that.
There's two ways that you can handle it. My suggestion is to do two separate motions. The ones that are currently in compliance but were not in compliance on the date that they were requested to be into compliance would be just that. There would be no fine running on those. And you could use those for a repeat violation in the future. The ones that are still in non-compliance, you would establish a date of compliance and a dollar amount of fine. So that's the way that it should be handled, two separate motions.
because I was just thinking this could come back to bite us in the butt, I would think, if we're finding them.
You cannot find them in violation if the testimony, only testimony that you heard was that they were in compliance. So you're correct.
So it's the 8-22, 40, and 52 are in,
No. 8-22 would be in compliance, and IPMC 302.4 would be in compliance. The other violations fall under all the other codes.
okay, thank you.
Has this 822 and IPMC 302.4 been a problem with this property? Is that why you were leaving?
Ongoing.
Ongoing?
This is a new property owner, but nothing really has improved.
Okay. All right. Would somebody like to make a dual motion on this?
I'll make a motion. I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations, sections 8-40, 8-52, IPMC 9-1, IPMC 301-4, IPMC 304-2.
Jerry, you mean 301-3, right?
301.3.
I'm sorry,
301-4, it's 301-3.
I'm sorry.
That's all right.
301-3, IPMC 304-2, IPMC 304-13 of the Code of Ordinance of the City of Tarpon Springs were in force. The respondents have until the 4th day of December 2013 to come into compliance with the code sections, or a fine of $50 a day shall be imposed for each day thereafter that respondents remains in violation of said code sections.
Second.
Okay. Board discussion? And Michelle, may we have a roll call
Sure.
vote?
Mr. Sobleski?
Yes.
Mr. Demontis?
Yes.
Ms. Archer?
Yes.
Mr. Vesey?
Yes.
Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Chair Sansota?
Yes. Did you want to do a motion on the other two? Jerry?
Yes.
Okay.
That's what you're revising, yes. All right, then, I have it.
You can do it basically the same way, it's just that not, once you get through the first narrative portion of it, you said they're now in compliance.
Now in compliance, okay, no fine, okay. I move based on the testimony, evidence, facts presented in law, that at the time of the alleged violations, sections 8-22, IPMC 302-4 of the Code of Ordinance of the City of Tarpon Springs were in force. And the respondents, well, no, not the respondent, that on November 13th, those two said sections were in compliance.
We need to get in there that they were in violation, though. So they were in violation of the original two, but they're now in compliance as
Okay.
of November 13th. The violation portion has to be in the motion, so.
Okay.
Yeah.
All right, let me go through this again.
You know,
What do I need? Do I need to read the whole thing again, or?
no, you just say, you just want to amend that motion to reflect that they
All right.
were in violation thereof and they're in compliance as
All
of
right.
November 13th, and
That I would like to amend that motion and say that on November 13th, they were in compliance on those two sections, which was 8-22 and IPMC 302-4.
But that they were in violation.
In violation prior to that.
that's good enough. That's what we need,
Okay.
yeah.
Do we have a second?
Second.
Discussion? Roll call, please.
Mr. Sobleski?
Yes.
Mr. Monsis?
Yes.
Ms. Archer?
Yes.
Ms. Vesey?
Yes.
Oh, Mr. Vesey, sorry about that. Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Chair Sansota?
Yes.
I think we can miss
All right. Item 6, please.
This is case 13-80000858. The property address is 725 Bayside Drive, and the property owners of record are Alexander C. and Rita G. Kaplan. We received a complaint on September 13th that there was a rear washout and a boat not stored properly on the property. I conducted a site visit on September 17th and found that the lawn was overgrown. There was a small boat leaning up against the side of the house, and there was erosion on the east side of the house. This property was in violation of codes 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, 42.00, parking or storage of recreational vehicles in residential areas, IPMC 9-1, International Property Maintenance Code adopted, and IPMC 302.2, grading and drainage. The property owners of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, were sent a notice of violation on September 17th and a notice of hearing sent first-class mail and certified return receipt on October 8th. A site visit was conducted prior to each notification being sent. The property was posted on October 30th. Yesterday, I conducted a site visit and found that the boat had been removed, but all of the other violations remain. The property is in compliance for Code 42, but in violation of Codes 8-40, 8-52, IPMC 9-1, and IPMC 302.2. I recommend a compliance date of December 4th, 2013, or a daily fine thereafter of $50 per day.
These folks living there,
No, it's vacant.
vacant?
It's an income property, and they've had a few like lease purchase options on it, and nothing ever really goes through.
Would somebody like to make a motion on item 6, please?
I'll make a motion. Sure. I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations of sections 8-40, 8-52, IPMC 9-1, IPMC 302.2 of the Code of Ordinances for the City of Tarpon Springs were in force. Also, Code -4200 was in compliance as of November 13th, 2013. The respondents have until December 4th, 2013 to come into compliance with code sections, or a fine of $50 a day shall be imposed for each day thereafter the respondents remains in violation of said code section.
Second.
Board discussion? Roll call, please,
Mr.
Michelle.
Zablesky?
Yes.
Mr. Demontis?
Yes.
Ms. Archer?
Yes.
Mr. Vesey?
Yes.
Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Chair Sansota.
Yes. Item number 7, please.
This is case 13-800000886. The property address is 715 Locust Street, and the property owner of record is Melissa H. Sussman. This was proactive on September 26th. I found the lawn was overgrown. There were several broken windows. The house was vacant. A lease pendants for foreclosure was filed by Chase Bank on June 4th of this year. The property was in violation of codes 8-40, duty of maintenance of private property, 8-52, nuisance prohibitions, IPMC 9-1, International Property Maintenance Code adopted, IPMC 301.3, vacant structures and land, and IPMC 304.13, windows and doors. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, was sent a notice of violation on September 26th and a notice of hearing sent first-class mail and certified return receipt on October 17th. A site visit was conducted prior to each notification being sent. Copies were also sent and emailed to Chase Bank and Select Portfolio Servicing. The property was posted on October 30th. A site visit was conducted yesterday, November 13th. I found that the front yard had been mowed, but not the backyard. The windows that were broken had been boarded up, not repaired. The house has been secured. There is furniture and other debris in the backyard behind the fence. This property is in violation of codes 8-40, 8-52, IPMC 9-1, IPMC 301.3, and IPMC 304.13. I recommend a compliance date of December 4th of 2013 or a daily fine thereafter of $25 per day. I've been in contact recently with Select Portfolio, and they assure me that they will get the rest of these issues taken care of.
Oh, good. Would somebody like to make a motion?
I'll make a motion.
I have a question first, please.
Go ahead.
If I may. The company that you said is going to take care of it, are they reputable and they're good for their word? Because my concern is that's a lot worse property and we're only charging them $25 a day. And the last one, we charged $50. I think with all the mattresses, furniture, and the infestation and everything in the backyard, they should have more than a $25 fine per day.
All I do is make recommendations to you. You can do whatever, you can set whatever
Okay.
fine you want.
Can I continue with my motion? Sure. All right. I move, based on the testimony, evidence, facts presented in law, that at the time of the alleged violations, sections 8-40, 8-52, IPMC 9-1, IPMC 301.3, IPMC 304.13, of the Code of Ordinances of the City of Tarpon Springs were enforced. The respondent has until December 4th, 2013, to come into compliance with the code sections, or a fine of $50 per day shall be imposed for each day thereafter that the respondent remains in violation of the said code sections.
Second?
Any board discussion? And Michelle, roll call, please.
Mr. Slabowski?
Yes.
Mr. Demotsis?
Yes.
Ms. Archer?
Yes.
Mr. Vesey?
Yes.
Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Chair Sansoda?
Yes.
No problem, brother.
Okay, item number 8, please.
This is case 13-800000967. The property address is 23 South Walton Avenue. Mike P. Clanaris is the property owner. Malad Mikhail of Flapatier Incorporated, Easy Stop and Shop, is the business owner. This is a repeat violator, case 13-800000741 of Code 181.00. This is a proactive case on October 28th of 2013. There were multiple signs on the support posts on this property and an EBT feather flag in front of this business. I initially noticed the signs and the feather flag on Sunday, October 27th, when I was out running errands. This property and business were brought before this board on October 10th, 2013, for the same violation. This property was in violation of Code 181.00, signs specifically prohibited as a repeat violator. The property owner of record, as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser, and the business owner were both sent a notice of hearing, sent first-class mail and certified return receipt on October 28th. The property was posted on October 30th. The feather flag and all signs were removed on November 1st. I conducted a site visit yesterday and found no illegal signs on the property. This property was in violation of Code 181.00 from October 28th of 2013 to November 1st of 2013 for a total of 4 days. I'm making a recommendation of a minimum daily fine of $100 a day times 4 days, total of $400. I will tell you that this property owner did place signs out again on November 9th and will be coming before you again next month.
This is a guy that testified at the last meeting.
Yes.
Yes, it is.
Gosh, he didn't get it.
They don't speak English or what?
He speaks very good English.
Jeez.
He was here in front of us, if I
Yeah, he
mistaken.
was mad that other owners were getting preferential treatment.
Right.
Yeah.
And he had to do that to get the people in off of Tarpon Avenue.
Yep.
So he was
Y'all
here
remember.
on October 10th and then put signs back out 17 days later.
I think that's definitely worth $100 a day. It's not like he forgot because it was a year ago.
Does anybody have any questions for the city? I'll take a motion at this time.
I'd like to make a motion.
Okay.
I move, based on the testimony, evidence, facts presented in law, that at the time of the alleged violation,
Different one.
Code 181.00 was in force, and the violation took place between October 28, 2013, and November 1, 2013, a total of 4 days. I recommend that the fine be $100 per day for each of the 4 days, for a total of $400.
Second.
Board discussion? Michelle, may we have a roll call, please?
Mr. Slabowski?
Yes.
Mr. Demotsis?
Yes.
Ms. Archer?
Yes.
Mr. Vesey?
Yes.
Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Chair Sansoda?
Yes. Okay, for the record, there's nobody in the audience for the affidavits of noncompliance. Bruce?
I move we accept the affidavits of noncompliance in case number 11-2000010 and case number 13-800000536, and case 13-800000676, case number 13-800000679, case number 13-800000709.
Second.
Okay, a motion and a second. All those in favor, say aye.
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 Opposed? Motion carries.
May I ask?
I-
Can I ask a question? Excuse me.
Yeah,
Pardon?
Go ahead. I have a question after
okay.
Ms. Casey.
I'm just curious, this big long one, is that church?
Yes.
Okay. Are they close?
Pardon?
Are they getting close?
It's not my case, it's Anthony's case.
Oh.
I have no idea.
Okay, I was just curious.
Tom, on the case that I asked you about, West Clanaris, there is an affidavit of noncompliance attached behind the repeat violation. Does that need to be voted on separately?
Yes.
Think,
So does everybody have a copy of that then?
behind the previous case, Clanaris that you just voted on as a repeat violator, there was a affidavit of noncompliance attached to that.
Okay.
For my case file to be clean, I would like the board to vote on the affidavit of noncompliance separately.
Bruce, do you have that in front of you? It's, where is it? Now, we're talking about, the,
Yeah, it's
To-
not on the non-compliance list.
but this is the
Correct.
one that we just,
Yeah,
okay, do you have the letter from Herb Elliott?
Yes.
You could read the numbers off of that.
got the numbers in front of me.
Okay.
Also, I move on affidavit of non-compliance
I don't
on,
think that's the right one.
No,
That's not the right one.
I'm asking for the
She's asking
affidavit of
about the
non,
one which is listed on your agenda as item number 8. That it's a repeat violator,
Oh,
correct?
Yes.
Canaris.
yes.
Okay. So,
Attached to that, your case file attached behind the backup, there was an affidavit of noncompliance.
so we need a motion to accept the affidavit of noncompliance. It's a matter of, just keeping track of the case. It did come into compliance after the notice of noncompliance, but there was a period of time it was not in compliance.
I'll do this. I move to accept the affidavit of noncompliance on case number 13-800000967.
do we have a second?
Second.
All those in favor, say aye.
Aye.
Opposed? Motion carries.
Thank you.
good.
Thank you, Michelle, for bringing that to our attention.
Good.
Compliance?
Are we ready?
Sure.
I move that we accept the affidavits of compliance in case number 09-800000044, case number 13-200000029, case number 13-800000536, case 13-800000582, case 13-800000967.
Second.
Okay, we have a motion, a second. All those in favor, say aye.
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 Opposed? Motion carries.
I'm sending these in recorded next month, I won't be.
You better be correct on your zeros. If we could have a motion to approve last month's minutes, please.
Well, they're actually the minutes for July, August, and September.
Okay, so can we do it in one motion, or,
Yes?
okay,
I have just a quick question.
all right.
Which entity are we supposed to be? Because in one of them, I'm listed as Mr.
Yes.
Okay,
We need to
well,
have the minutes be accurate, so if there's a typo, we need to bring that to the attention.
I read it online, so I think it might have been the first one, July.
Okay?
I'm listed as Mr. V. Casey.
Oh,
Maybe I made a motion like in
No,
the
you're
first
right here.
case.
you're correct.
Okay.
And they're still referring to Tom as the city attorney.
Yeah, I'm the board attorney in all of the minutes, Michelle.
I have it corrected on here. It
Okay.
says board attorney.
Okay.
No, but in the narrative part,
Okay.
they they still say city attorney dress.
All right,
get
so we'll
that
just do
corrected.
those next month. You know,
You
the
gonna
rest of
postpone
that
these then?
alligator, that's probably why they said Mr. Crocodile.
We can approve them this month. They don't,
Now that they're
Now
amended.
that they're amended? Okay.
with the amendments.
Yeah.
Oh,
I
great.
move to accept the
Okay.
minutes for the July, August, and September meetings
As amended.
as amended.
Do we have a second? Second. Thank you, Becky. All those in favor say aye.
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 Opposed? Okay, motion carries. Be thinking about, we have to do our elections next month for a chair and a co-chair, what do you call it?
Vice Chair?
Vice chair.
In charge of vice.
And so be thinking about who you'd like to sit here and there. Also, I want to read a little letter to you in response to some of our discussion last week. This is from Chief of Police Robert Cochin. And where it applies is Police Department, during the agenda item discussed ensued regarding unsafe swimming pool, board felt wasn't being addressed appropriately. The Police Department utilizes an executive process called abatement under City Code 8-56 that is set in place to bring into compliance our worst properties or to remedy life safety issues. We have used the abatement process on 64 properties within the last several years. Some of these abatements did involve life safety issues. To include the abatement, we did in April of 2013 on a large deceased oak tree that could have fallen on a neighbor's house on 1112 East Oakwood Street. We take all life safety matters very seriously. Our process to remedy these normally occurs as follows. Number one, the code inspector identifies the life safety concern, reports it immediately to our supervisor, Sergeant Edward Miller, or to the operations captain. Two, Sergeant Miller meets with me, the chief of police, to discuss the severity of the life safety concern. Number three, if the life safety concern demands an immediate remedy, I consult with the city manager to determine if city crews need to take action. Number four, other code violations that need to be remedied through abatement are handled through the process under City Ordinance 8-54. I'd like to reiterate, this is the Chief of Police, that when it comes to abatements or life safety concerns, we take all these matters very seriously and have a process in place. On a note here, items discussed on agenda item number 7, October 10, 2013, Code Enforcement Board meeting has been brought into compliance as of October 15th. And then I ordered a review of all of our pending pool cases to determine if any life safety concerns existed. This review was conducted. It was reported to me that currently no pending pool cases have any life safety issues. So thank you guys for bringing this up last month, and I appreciate your help on that matter. Any other board or staff comments?
Yes, I have a question. In our July 11th meeting, I thought, postponed a case for November 15th for this meeting. Because we needed more, I think Carl was wanting more pictures, or we're going on word of mouth or something. No? Oh, that's the one we postponed again today?
Yes.
Okay, I'm
the
sorry.
reduction
Thank you
of
very much.
Yeah, there was
You've got
no
a good
witness,
memory.
All right, okay.
there was no witness from the city. He was here today, but the other side wanted to postpone.
Okay, thank you. I just didn't.
Any other comments?
I would just like to ask Tom what's going on with Tommy and where's he at?
He's still at Fort Benning in Columbus, Georgia, and he's still doing his Bradley fighting vehicle work. He's a sergeant now, and he's supervisor of 10 soldiers under his command. We're waiting for his deployment orders because we figure that they will be coming. We just don't know when.
Does he know maybe where?
No. They don't tell the soldiers until about 72 hours before they go.
Oh,
So,
And is his hand okay now?
yeah, his hand is much better. He's able to fire his weapon.
Okay.
So thanks for asking. I appreciate it.
I think about him a lot.
Yeah, I think about him a lot, too.
I'm sure you do.
Thank you.
I'd like to return to that request about the July 11th property. And I happen to have a copy of the minutes from that same meeting here, and this has been on the back of my mind. I want to make sure that we're clear about that. I don't think the Ballyhoo property that was postponed today is the property that you might have been discussing. I believe the property that you're questioning is the Tarpon Avenue.
Yes.
1
119 East Tarpon Avenue.
Super, okay,
Oh, that's a
good. So,
compliance, their compliance date is tomorrow.
so they missed it by a day.
Okay.
I shouldn't speak, but
They have to be in compliance tomorrow, or today, and the inspection, or when is the compliance deadline? 15th? Compliance deadline's tomorrow. Joey will be inspecting it on Monday. And then it'll be brought to you next month.
That's the
All right.
appropriate way to do it.
So it'll either be in compliance or not in compliance. But that was a compliance deadline that y'all set for it.
I hope you all have a happy Thanksgiving.
I have one quick question for the chairman. Good night. You indicated that next month we're going to have elections. Are you a candidate for reappointment to the same position that you've held? Or?
Yeah, but any one of us can be a candidate, so if you guys are tired of listening
I
to
don't know, we
me.
need term limits here, I'm sorry.
Thank you.
I'm
Oh,
not sure if
just-
we'd be doing you a service by reelecting you for yourself or whatever. I just wanted to know if you were interested in it.
Well, we railroaded them last time, so he may get railroaded again.
He doesn't get much.
I don't mind, it
Spent
just,
44 years working on the railroad, so I'm an expert at that. But I just wanted to know, Mark, if
well, thanks
there
for
was a
asking,
term
Carl.
limit or if you were still interested in it.
Yeah, I don't mind at all. I just, it makes it tougher to call in sick is all.
Okay.
Just so y'all know, we're not going to have a January meeting, so you can make your holiday vacation plans accordingly.
Okay,
And we will have a meeting in February and so on and so forth.
all right.
I have one more
Yeah.
topic of just discussion that would relate to our policy for the reduction in fine procedure. In the inside of the binder that we get every meeting, this first 5 or 6 pages is the rule that we're to apply for, fine reduction requests. And if you flip through it, you can see how it has, that particular resolution has been amended every 5 or 6 years by boards. We've heard some cases in the past, and we're going to hear some in the future, and it strikes me as interesting that we're required to only use as evidence a letter sent from the requester, and according to the last resolution, a response letter from the officer. Some of these cases are very complex and have a long history. And only because the subject was brought up today, I'm not discussing the case in specific, but I think it would be helpful if the minutes of the meeting at which that case was initially brought and ruled on were provided. Because some of these cases last a year, 18 months, or even longer before a reduction of fine is made, and the board has changed. And there might only be one person that actually recalls from memory what really went on at that particular meeting. I just find it hard to imagine that when we're deciding something so important, because usually the dollar amounts are pretty large, that all of the facts, just not the ones that happen to be remembered by the two parties, are brought up. So there's just a thought as we move forward and we hear these reduction requests, that perhaps we're not seeing the whole picture when we're making the decision, because right now, by resolution and rule, we can only see those two pieces of paper. And I just think that there's a lot more that would help us make a better decision. That's the end of that. Thank you.
I agree.
All right, the lawyer's going to jump in.
Yes, please.
Okay. You're the judge and the jury of every case that you hear. The judge gets to make the decision based upon the evidence presented to him or her. He doesn't get the opportunity to choose which evidence is presented to him or her. So if the city wants to give you that evidence, they can. If the respondent wants to give you that evidence, they can. You don't get to choose what you hear and see. You know, I think that what you're hearing from the code enforcement department is hearing what you're interested in, and now they'll make that decision whether or not, when they issue their response letter, whether they're going to add that information. But we're curious, we want to know, you know, we want to delve into things, but being a quasi-judicial board, that's not your role. And it's not, sometimes it's really not fair, and it doesn't make sense, but that's our role here. And so we don't always get to decide cases on the best evidence. We get to hear and decide on the evidence that's presented to us. So
Even the minutes of the meeting of the same board of our own action, that wouldn't just be record, that would be, we provide pictures.
They're not, you're not, what you want is a verbatim, and you're not getting that in the minutes. You're getting a Reader's Digest version of who made the motion and what the violation was, and you're not going to get that out of the minutes.
No, we won't.
When it's one of my cases and I respond, you will get when it started and when the NOV was sent out and when this was sent out, and you'll get more specific information. And if there's any issues, that will go in my report, as well as, you know, recommendations. So
as to the minutes themselves, the lawyers call that judicial notice. You can take judicial notice because of the fact that there was some document or some part of the file, the court file. You can take notice of that, but you don't get to decide whether it's presented to you before you can take judicial notice of it. It's the city or the respondent bringing it to you, and then you can decide, you know, whether or not, or they can decide whether they're going to present it, and you can decide whether or not you're going to receive it. But again, you don't, just think about, you know, as a criminal trial, someone is they've been charged with murder, and you want to see what the murder scene has provided because you're curious, but the state only presents DNA evidence of one blood splatter, okay? You don't get, that judge doesn't get to make that decision as to everything else that's being presented. He only gets to make decisions on what he's given. So it's hard.
That makes sense, though.
But that's just the way that it works. But I think that you've made it loud and clear that, this is how you do it. If there are things that you think are important, now they know that, and they can make a decision whether or not they think it's important to give to you. So those are all good points that you brought up, but I just want to, you know, you can't take a proactive role in trying these cases. You just have to, you know, perform your role, you know, when it gets here.
So I shouldn't go back and review the video from the previous meetings to refresh my memory?
Absolutely not.
Because that's really hard and time-consuming anyways, because it's not detailed.
Absolutely not.
I didn't see that in my sunshine rules, but I'll add that at the bottom.
Well, it's not part of this. The sunshine law is to make sure that your meetings are open to the public, that notice has been given and minutes are going to be taken. That's all that is to make sure that you don't do anything behind the scenes. The public record law is to make sure that all the documents are available to the public. Those are the two basic laws. But what we're talking about here is a quasi-judicial activity, and they have their own rules. And you have adopted some of them in these rules of procedure that have been in place since I've been here, almost 20 years. They were adopted before I got here, and they haven't really changed that much. You've made mention of a couple of them. I've been involved in those changes, but those were literally just, should it change from 30 calendar days to 30 work days, then it got changed from 60 calendar days to 60 work days, and then it was changed to, well, if they get to give you something in writing, why can't they give you something in writing? It's just, a matter of fairness. So those are really the only changes that have been made in the last 20 years that I know of. But the reasons why it's all done by paper, by the way, is it's almost like an appeal. You don't really get, when you do an appeal, you don't get the right to try your case all over again. And so if you did that, you'd never get anything done here. You literally wouldn't, because you would be case after case. You would hear the case, it would be tried, they come into compliance, you'd have a trial on that or hearing on that, then they come into code violation reduction, you try in that, you'd have like 3 trials or 3 hearings on every case. And, and I've been here when we've had 40, 50 cases going at a time. Here tonight you've had 8, or I think 8. So just imagine, what your role would be if you were to have a full-blown hearing on those things and let testimony come in at those types of hearings. It doesn't mean that you can't. It just means it's out of the ordinary. So,
40 or 50 cases.
yeah.
I
We've had those in the
do
past.
think, Cindy, I've noticed that on some of these fine reductions, that she puts in if it was a difficult case, and I that's what I want to know. Do we reduce this fine even though she's got hundreds of hours in on it? And I think that's something that we need to consider.
I'll let you know how many times I was there and what
Yeah.
our costs are estimated to be, and whether they're likely to commit, the infraction again. And
All the meeting information came on to my computer, and it was flawless. That worked out really good this
Good.
time. All the minutes came in. I didn't have to click 8 things or get out a book.
Good.
So,
Look,
I think you got A's on it.
everybody's here, 100%.
Every-
Thank you for everybody showing up. Any other board discussion? Anything else?
I just want to wish everyone a happy and blessed Thanksgiving, you and your families.
You too.
Yeah. All right. Well, it's 2:56. Code Enforcement Board stands adjourned.